Ladies and gentlemen, my name is Akim Olajide Bello. I'm of the Faculty of Law, University of Lagos, and it is my pleasure to welcome you to this afternoon's program. The program is one of the faculty's series in our roundtables and workshops. At these workshops, we try to focus on contemporary legal issues, and we try to add the voice of the faculty to such contemporary issues to shape the discourse, and where necessary to point attention to areas of necessary intervention. So today, it is my pleasure as the chairman of the Faculty Roundtable Committee to bring to you this virtual discourse focusing on interrogating the limits of the criminal law in regulating freedom of expression, sedition, defamation, etc. So we'll be focusing on examining the limits of the criminal law in regulating freedom of expression. We have assembled an eminent panel to help us look at this issue. We have Professor Ayodele Ashenua, who is the Deputy Vice Chancellor, Development Services of the University of Lagos. She's also of the Faculty of Law. We have also Mr. G.T. Oguye, who is an eminent legal practitioner and a public commentator. Then we also have, to hear the voice of the youth, we have the president of our Law Students Association, Mr. Timothy Ayoride, who is also joining us to bring the perspective of the youth to this discussion. So essentially, that's what we are going to be doing today. We all know the controversy surrounding some recent publication, and the issues of defamation surrounding those issues. We know that that issue is currently sub judice, so we are not commenting directly and specifically on the issues. I'm sure, to be more specific, the litigation involving Mr. Dele Famoroti and the distinguished legal practitioner, Shifafero Balola. We will not be making any comment on that case because the matter is sub judice. All we will be doing is to review and interrogate the limits of the criminal law in regulating freedom of expression. We'll look at issues surrounding that and what are the permissible limits of freedom of expression permitted under the law, and whether, and to what extent
the criminal law energy, right?
And the extent to which
I'm just wondering how I can't even know what has
freedom of expression
already.
And we didn't drop me before. Don't drop me on my phone bounce back.
That's what I'm saying. I noticed that my own.
the Dean of the Faculty, Professor Abiola Ese, to give his welcome speech. My dear, sir, my dear.
All right, thank you very much. I hope you can hear me.
Yes, we can hear you loud and clear.
Okay. So good afternoon, distinguished panelists, colleagues, students, and members of the audience. Let me especially appreciate Professor Ayo Asenua, the DVC Development Services, and my learned friend, Comrade G.T. Oguye, for sparing time to be part of this. I warmly welcome you to this important conversation. This event, curated by the Roundtable Committee, marks the first in the series of our proposed intervention as a faculty of law. The Roundtable Committee is one of the 18 standing committees established by the Faculty Board of Studies to set our faculty on the path of sustainable progress. If you find today's program valuable, as I'm sure you will, I encourage you to stay tuned for future events. As Lao Tzu aptly said, a journey of 1,000 miles begins with a single step, and today marks that step forward towards informed conversation and driving necessary reforms in our legal system. Ladies and gentlemen, allow me to clarify what today's discourse is not. This is not about the case of A.G. Ekiti and Farotimi or any pending cases. As legal practitioners, we are keenly aware of the principle of sub judice, which ensures proceedings are not prejudiced. Lord Denny put it when he said, the course of justice must not be deflected nor interrupted. That said, academic freedom allows us to discuss substantive legal issues, comparative system and legal frameworks, provided we do not join the fray. And by this I mean, provided we do not discuss the substantive issues before the court. Justice Echo, in the case of Kalu and Federal Republic of Nigeria, reinforced this principle when he said, once a writ is issued, it puts a stop to discussion, except in matters of public interest. We are gathered here in public interest. So this conversation is both timely and vital. No matter how brief it may be, it has potentials to trigger law reform. Professor Akeem Oladijide Bello used to be the commissioner for law reform in Lagos. So looking at the turnout, it is only fitting that we ensure that as many voices as possible are heard. So I will be requesting the moderator to please grant an extension of 30 minutes so that we can have robust discussion from the audience. While we are privileged to hear from our erudite panelists, it's important to note that their views are personal and do not necessarily reflect the position of the University of Lagos or our faculty. So I trust that the press will report accurately and properly attribute remarks and avoid any misrepresentation. So finally, I thank Professor Bello and his diligent and enthusiastic team for their tireless effort in putting this together. Ladies and gentlemen, this is only the beginning. I leave you with the words of Roscoe Pants when he said, the law must be stable, but it must not stand still. Let today's conversation inspire reforms that will balance free speech with accountability and also public order and democratic tenets on the other hand. So thank you. Welcome once again. Let the conversation start right now. Thank you very much. The moderator, over to you.
Thank you very much, my dean. I would like to briefly introduce our panelists so that we can start. We have with us, joining us in this discussion, Professor Ayodele Ashenua. She is the Deputy Vice Chancellor, Development Services of the University of Lagos. She was also formerly the Dean of the Faculty, University of Lagos. And at one time, she was head of the Department of Public Law. She's a leading human rights and women's rights advocate and has led and currently leads many research projects in this field. Professor Shenua is also one of the foremost teachers of criminal law in Nigeria, where she teaches criminal law at undergraduate and postgraduate levels. She's also involved in teaching and research in the area of sentencing, treatment of offenders, and criminology. She was the chair of the Criminal Code Law Reform Committee of Lagos State, which was constituted sometimes around 2010 to review and reform the criminal law of Lagos State. It was that review that led to a new criminal law of Lagos State 2011. Later in the course of the discussion, we hear about some of the things that was implemented through that reform. So we are privileged to have with us Professor Ayodele Ashinua. Thank you very much, Ma. You are welcome. I would also like to briefly introduce Mr. GT Oguye. Mr. GT Oguye is a lawyer and principal counsel, GT Oguye Chambers. He was once of the law firm of Mr. Femi Falana Chambers, where he worked several years. And he has had a career in legal practice that is intertwined with human rights, pro-democracy, and legal activity. He was very active in human rights and pro-democracy movement, which championed the struggle for the termination of military despotism in Nigeria. Mr. Oguye is an author of 3 books. He's a public interest lawyer, publicist, law reporter, legal commentator, author, essayist, and poet. So it's our pleasure to formally welcome Mr. GT Oguye. And then we also have in our panel, Mr. Timothy Ayoride, who is a final year law student at the Faculty of Law, University of Lagos, and the 55th president of the Law Student Society. He's a seasoned law student and a passionate advocate for justice. Timothy has excelled in leadership and advocacy through his academic journey. So it's our pleasure to have him contribute the views of the youth to this discussion. So Mr. Timothy Ayoride, you are welcome to this event. Now, let me just give us a brief overview of how the discussion will proceed henceforth. There will be 3 rounds. So in the first round, we will have our panelists respond to specific questions. And then after that, we'll do a second round. And then we'll do a third round. And there will be opportunities for comments and questions from participants. And then also opportunity for responses from the panelists. And then we'll have opportunity for parting words, the panelists. And then so we hope to be, able to leave here in about an hour's time. And I'm not unmindful of the dean's request for an extension of time. Yes, we'll also try and accommodate that while trying not to keep you for too long. So, ladies and gentlemen, we'll begin the discussion now. So the round 1 will start now, and Professor Ayodele Ashinua will give us the first Sure. Now, ma'am, I know that you are the chairperson of the committee, the Criminal Code Law Reform Committee that was constituted by the Lagos State Attorney General sometimes in 2010 to review the criminal code scheduled to the Criminal Code Law of Lagos State. And one of the highlights of the reform under that new law that was battered by the work of the chairman was the decriminalization of sedition and defamation in Lagos State. So, Mark, can you please explain to us what is the rationale for decriminalizing sedition and defamation in Lagos State?
Thank you very much, Mr. Moderator, and my warm greetings to the Dean of Law and my co-panelists, as well as participants in this discourse. I want to thank you very much for the opportunity. And I want to restate, as the Dean did say, I think that my standing to speak during this discourse rests only on the basis of the work that I have done in the area of criminal law and criminal justice. And so I do not speak for University of Lagos as Deputy Vice Chancellor. And the University of Lagos, as far as I know, has no position on this, on the issues that we aim to discuss. So the views are for my views resting on the work that I have done. Yes, indeed, I was chair of the committee that revised the criminal law of Lagos State between 2009 and 10 until its 11 until its formal adoption in 2011. I think the question that you ask, what's the rationale, can only be answered when we avert our minds to other questions. First of all, what is a crime? What should the criminal law punish? What is the purpose? What purpose does the criminal law serve? What is the basis? Do we have coherent principles for to justify why a particular act or conduct is criminalized and another one is not? Should the criminal law interest itself in what is private interest and seek to support the private individual to protect their private interest? And if so, how far? Then the question of efficiency of the use of the resources, of the public resources, which is what criminal law is all about. And when we looked at this, we thought to ourselves that the only way we can answer this question is by saying, what exactly is the purpose of the criminal law? The purpose of the criminal law is to, now this is loosely speaking, I mean, this is a question that so many chapters, volumes of books have been written on. But the criminal law in a nutshell is about defining, the law of crime is about defining which conduct the society comes together to give their backing to as not good, not serving its interest, and must be prohibited. Must be prohibited using, you know, all the resources of the public. Don't forget that in crime, it is the state, it is the people against the criminal offender. In crime, sanctions come largely very punitive in the name of the people and the state. So it must be something that really attacks the interest of the people. And as we do that, it takes us to criminalization. Why do we criminalize some things? They must go beyond the fact that it is just simply a wrong. And then we also considered the history when we looked at the public and the private. And we looked at the history and we found that to a large extent, sedition, for example, was simply used by the colonial government to silence dissent, because there was no way you could be critical of government without being seditious. You cannot say this government is corrupt and be able to say it is corrupt having the facts. How do you foster? How do you create awareness, knowledge? You know, we say people have a freedom to choose and to form, to form opinions, but they are only able to form opinions, and the opinions are only informed if they have access to information. Where the threat of punishment hangs, then it's very likely that many people will be intimidated and silenced because of the threat of punishment. Then I said earlier on that we also need to answer the question about efficiency. And we must try to discourage what we call the weaponization of the criminal law. In the discourses about, the law of crime, that there are many people who have said that the problem with the law of crime is that it criminalizes what the disadvantaged or the vulnerable or the weaker in society does, and, it gives power and leverage. I don't want to go into all those discourses, but those were some of the critical concerns. If there is there is no sedition. Sedition is against the state. Defamation can be against an individual. But the issue with defamation is that it is still a civil wrong. And between the parties, they can resolve their wrongs. We're looking at efficient use of state resources. So yes, it's nice that people's reputation, it is nice that people's trade and profession should not be harmed, but we believe that these are things that people can do on their own. We're also mindful of the shifting, what I will call the, I don't know whether I want to use the progress, maybe I'll use the word tolerance. We're more, the modern society is supposed to be more tolerant of people disagreeing with you and disagreeing with you very strongly, people expressing themselves so that information is communicated. Of course, this is not to say that just everything passes, but we must, with the fact that it is protected by civil law, especially defamation, means that there is an opportunity, to seek justice in case, if the victim believes that they have been wronged, and they can go to civil justice. So these were our considerations. We looked at the risk of weaponization of the criminal law, given the history of these offenses. It's interesting. Everybody abuses themselves on the streets of Tejuosho, and they call themselves thieves and things like that. Pushed to its logical conclusion, almost every person will be asking the police to support them, to get justice against the wrong of defamation, if we leave it as loosely as if someone says that Professor Shenua does not know anything, she's not even, they should not do whatever, and that even the papers that she got, it is, I can always sue. But if the state has to chase, for each of those our complaints, that we will certainly get ourselves into ineffectiveness and inefficiency. But on the issue of sedition, it was simply that the state, there is no way an opposition in a democracy will be able to speak without committing the offense of sedition. Because for sedition, truth is not even a defense. What would you say to say that don't vote for this party or don't vote for this government without you bringing the government into disrepute? If you say, oh, this government is not effective because they have failed in this area and that, necessarily you'll bring the government into disrepute. And that is going to be sedition under the old law. And that was why. And then we also had jurisprudence that had emerged out of the courts, where it was said that, look, we can't sustain sedition if we are genuine and we are committed, in fact, to promoting differences of views expressed, in a democratic society.
Thank you very much, Prof. Thank you very much. Now, we can see from your discussion some of the rationale, behind decriminalizing sedition and defamation. Now, I want us to move in a slightly different trajectory. The freedom of expression is one of our constitutional rights as citizens. And I want Mr. G.T. Oguye to help us respond to this. What is the value of freedom of expression in a democratic system? What value does it have?
Yes, thank you, Prof. The Dean and the other professors here present, including the Deputy Vice Chancellor, Professor Ayashenoa, my co-panelists, and everybody here present. I'm delighted to be part of this eminent search for knowledge and for cross-fertilization of ideas in an area that has recently become very controversial. I know that in the best tradition of the academia, when there's so much confusion in the town, began as a guardian institution, weighs in a very sober, calm, introspective, and very far-reaching manner, because we are talking about a body or institution that is dedicated perpetually to the search for knowledge, to the growth of knowledge, to the expansion of knowledge and seeking of the truth. So it's indeed my good fortune that I'm invited to this program. Now, the question that has been posed is a very important question. The right to freedom of expression is a very fundamental right. And I say this not because only of the provision of the Constitution that has categorized it as fundamental. Right from the cradle, when a child is born, if that child doesn't let out that pristine cry, everybody will be in a state of panic. The parents of the child, the doctors, because that could indeed be having of a lifelong situation. So everybody will want the child to let out that first cry first. The ability to speak is very basic to mankind because that's how we express ourselves. Yes, of course, we know that a human being can express himself now either through writing or in other forms of expression. But the right to freedom of expression is all-encompassing. It is not restricted only to speaking alone. The expression is more extensive and more expansive than the ability to speak alone. And so, in answer to that question, we just look at what the Constitution has provided. Section 39, Article 9 of the African Charter on Human and People's Rights, Article 19 of the Universal Declaration of Human Rights. Essentially, what the right does is to bestow on us an entitlement to express ourselves, impart ideas, and share information. Hold it first. It bestows on us the right to hold it, because you may hold an opinion without actually expressing it, meaning that we have the liberty to hold an opinion, express the opinion, and to share our ideas and views with other persons, express our feelings and all that. And again, it also protects the right or our ability to own a medium, establish a medium for the expression of our views. Of course, this is subject to regulation. Now, the right to freedom of expression is also very important to a democratic society. Indeed, for other forms of government that are not regarded as democratic from ancient time to now, that right to freedom of expression has been a kind of distinguishing factor by which a system of government can be assessed either as despotic or democratic. Because it's generally known that in a democracy, the right to freedom of expression is held as sacrosanct. A government that is in place and is not doing the right thing, loosely speaking, can be criticized by those who are in opposition and those who may not be in opposition to it, who are just opposed to the policies and actions of the government. And we know that those who govern have the disposition or tendency to control those that they govern, particularly regarding what they say about them. So in a democracy, the right to freedom of expression is very important. And the duty that this right bestowed on us, and I'm talking here in terms of the division of rights from responsibility, because we usually say that once you have a right, then you also have a corresponding duty or responsibility. I'm not talking solely in respect of that yes, your right to freedom of expression also has a corresponding duty that you do not defame people and all that. That's not what I'm even saying presently. What I'm saying is that the duty that right bestows on us is a duty that stems from being a citizen. You are not expected to have a right for having its sake, so to speak. That right imposes a duty to be able to say something about society, about the community, about the government, about the institution that you work in, so that it can better perform the task of society, community, institution, and all that. So the right is important because if the rights were not there, one would not be able to exercise this responsibility or perform this duty I've talked about. Of course, the issue of being responsible with rights is important because virtually many of the rights that are considered as fundamental in our Constitution have derogations. That's why it is said that these rights are not absolute and that the right also includes the responsibility to respect the rights of other persons.
All right. Thank you very much, Mr. GT Oguye. Yes. I will now move to Mr. Timothy Ayobele. Mr. Timothy, you are the president of the Law Students Association. And we know that the young at heart are very active on social media, posting, expressing their right to freedom of expression. Like Mr. GT Oguye had said, it's very important in a liberal democracy. I want to know, Mr. Ayobele, do you and your peers have an understanding of liabilities that can arise from posts, from things that you post on social media?
Good afternoon, everyone. Good afternoon, panelists and the distinguished professors, academics, and the audience. So, with respect to the liability of individuals posting false information on the internet, one of the beauties of information communication technology and the rise of the internet is the decentralization of news media. We now have a situation where people all around the world, wherever you are, you can post something online. But this has created an ambivalent situation, a situation where we have the positive impact and as well as the negative impact. On the positive impact, we have a situation where the youth in the society can articulate their thoughts without the institution to scrutinize this information being pushed out. But on the other part, which is the negative aspect, the issue we face is that due to this lack of scrutiny by the recognized institution, the news media, we now have a situation where people push false information. And this can come in three ways. It could be misinformation, which is essentially posting things that are not true without having any malicious intent. We could be disinformation, which is the deliberately posting things that are false. And the other one, which is posting information that is true, but with in a way that
Moderator, I think you have muted the speaker.
Yes, it's a mistake. I was trying to mute somebody that was disturbing. So you can unmute, Mr. Yori. Unmute. Sorry about that.
So on the liability aspect, I believe that it is generally understood that posting false information creates a corresponding liability. It is a right which has liability. So that is already settled and it is recorded in the criminal code, which criminalizes things like defamation, and it also attracts civil claims in favor of the victim. But on the larger spectrum, which is the effect of false information in the society, it has various effects. The first one being the effect it has on the institution, the credibility of the news media. False information poses a risk on the trustworthiness of the news media. It also creates a situation where we have attack against specific groups. We could recall that in 1994, the Rwanda genocide, which was perpetrated by false and misleading information about the Tutsi people, and this led to over 800,000 deaths recorded in 100 days. And we also can recall the 2014 Ebola, where misinformation such as use of salt was being spread across the internet as a cure or prevention for Ebola. Also, on the third aspect is that it also has a ripple effect on global opinions on the society at large. So essentially, aside from the criminal aspects of the liability, it also has ripple effect on the institution with respect to attack, with respect to discredibility of the news media, with also respect to global opinion on the society at large. Thank you very much.
All right. Thank you very much, Mr. Ayoride. That brings us to the end of the first round of our discussion. Now, we want to move into the second round, where we'll begin to look at the jurisprudence behind imposing some limitations on the exercise of freedom of expression. And then also, we will look at some provisions of the law which have imposed some restriction on the exercise of freedom of expression, the violation of which criminal liabilities may ensue. So we'll also look at that in the second round. So, Professor Shenoa, we'll start with you again. We know that the freedom of expression is not absolute and is subject to Section 45 of the Constitution. Can you briefly explain the jurisprudence behind permissible derogation from freedom of expression? The jurisprudence behind permissible derogation from freedom of expression. Thank you.
Thank you very, very much. In starting this, in trying to answer the questions or the issues you want me to address, I think I really need to express my appreciation to Mr. G.T. Ogunye for, first of all, laying the very solid foundation of the jurisprudence that underpins the right to freedom of expression. Because it is when we understand the aspiration behind, and I use that word with emphasis, the aspiration, the value that society seeks to preserve, that underpins the right to freedom of expression. That is when we will understand the jurisprudence that permits the limited derogation from that right. Yes, in one, I think part of his closing statements was that, of course, most rights, and in fact, all rights with the exception of one, is, in fact, it depends on the jurisdiction. Almost all rights have some clawback. But when it comes to the derogation clause, it's very, what most people do not take care to look at is that it says you can pass a law that derogates from the right to freedom of a host of rights, but in this particular case, the right to freedom of expression, provided that law is, number one, reasonably justifiable. Reasonably justifiable, two very important words. In a democratic society, a very important phrase. A democratic society in its very nature is a society that represents that it has space for differing opinions, and that those differing opinions are just as legitimate, you know, and can always find expression in partisanship and expression at the polls. In the interest of defense, public safety, public order, public morality, public health, or for the purpose of protecting the rights and freedoms of others. Sometimes people just look at the grounds and they just list and say, oh, this law, because it's in public interest, or this law because it's in, it preserves public morality. No, it's not enough that it preserves public morality or public health. It is to be subjected to another level of test. So fine, on the face of it, this law looks like we need it. And I remember that during the COVID era, the House of Representatives were going to pass some laws. And again, the Faculty of Law had to respond to it and say, no, these laws are overreaching the interest of public health. And in fact, if you're not careful, you will undermine the interest of public health by going too far with those laws that, compel maybe mandatory vaccination, where, if I don't want to be vaccinated because on grounds of religious beliefs, should I be subjected to vaccination? And, laws that talk about quarantine. If I know I'm going to be quarantined, and if we can recall the circumstances surrounding the Ebola case, the first, the index case in Nigeria, it's that we're always constantly balancing. From my experience as a lawyer who worked in public health from the perspective of human rights, the initial public health response to HIV/AIDS was actually the bane of public health, because later we now needed to start relaxing the public health, the response to it. So it's important for me to emphasize that at any point in time, the courts will be required to ask if it was reasonably justifiable in 1940, because that was where society was, its values. It probably, in the 1940s, when the elders finished speaking, that was the end of it. There was no place for the youth or the child at the table. It wasn't perceived. We even had a whole system of law that did not regarded, in some cases, the child almost as ancient Roman law, yes, for some time regarded the child as property of the father, and much of law was shaped around that. Even though, the hold was loosened, the patriarch doctrine hold was loosened as we went from time to time, but it's always important that we recognize that what's reasonably justifiable is not static. And you recall that in my earlier intervention, I did make a reference to, in a society that is more tolerant of differing opinions, in the society that recognizes or is increasingly accepting of diversity, then what is reasonably justifiable will be something that is tested by, what the standards are now. Do you need to have sedition to protect, to protect public order, to protect morality, to protect so many things? Are there not other ways that you can protect the rights? So the last speaker made some reference to the net effect of liberalizing, the media. And now everybody can publish anything that it is that they want. And we are working for its responsible use. But is the only way of securing responsible use through the use of the criminal law, or is a problem of what I will describe? I don't know what the media experts, the phrase that they have coined for its technical phases, but I would say what I would call elite ignorance, media, social media related management ignorance. Because for example, I know the young people mock at we older people and say, you're just always forwarding, you're always forwarding. I think what we need, without necessarily falling back on the criminal law, will be a lot more education, a lot more savviness, building the capacity of society to be able to work with information. So for the sake of emphasis, I think I would say that yes, it is not absolutely free. The jurisprudence is very clear. The jurisprudence, like Mr. G.T. Ogunye said, the aim of the derogation is not to make nonsense of the right in the first place, but to recognize that there might be those exceptional instances, some of which I might say that, okay, we talk of cyberbullying. Now that is bullying, cyberbullying. We talk of hate speech. which is directed at communities of persons of which a particular individual can be a part. But I think that those are, we didn't know hate speech, or maybe we didn't define it as hate speech. We had offenses such as insult to religion and all of those things. But so we can have new wrongs that, and hate speech, we will say, is reasonably justifiable, and it is worth criminalizing, because at that point in time, what you're looking is the interest of diversity in the society, which hate speech undermines. The risk to personal and proprietary safety, the risk to public order, are all the things that are implicated. And in this regard, completely different from something like defamation. So it is ever growing. The jurisprudence has room for growth as society evolves. But the question must always be, it's not just enough for it to be justifiable on those grounds, reasonably, in which case you're balancing, you're measuring, you're weighting, and then those other grounds. And what is national interest is something that we also, is not fixed, it's not static. There were times when the Nigerian state described anybody who said anything against the state in the military time as subversive elements. And we do know, for those who may be younger in this discourse, I would want you to just search and do your research into what is called Decree 4, that was used to gag, and was basically like for some of the excesses and say, oh, in national interest. And some journalists of repute of those days, simply because they published some stories in their news journal, were to be executed, because that was the military. So national interest does not always coalesce. What you call national interest, I may not call. When there was famine in China, it was national interest of the communist government to keep silent about the fact that people were dying. And they regarded it as national interest. So it's not static. And then how, the values, and that's why you actually need that freedom of expression to be able to demonstrate that what is being described for this moment as national interest is actually not national interest, or even later in time. And that is also why we now have a whole legal framework that protects the freedom of information, which even goes beyond which goes beyond just being able to share information, but facilitates access to what used to be official information that there was almost nil access to. So I think I would pause here so that my other colleagues can speak and we can move on. Thank you.
Thank you very much for laying the jurisprudential basis for permitting derogation from freedom of expression. And in the light of that jurisprudence, we would like Mr. G.T. Ogunye to use that jurisprudential basis to extract 3 provisions in our statute books that restricts to some extent the freedom of expression. And these are section 24 of the Cybercrime Prohibition and Prevention Act 2015 as amended, section 59 of the Criminal Code, and section 204 of the Criminal Code. Are these restrictions under these provisions within the permissible limits of derogation? Mr. G.T. Ogunye.
Yes, thank you very much. Before I answer your question, let me say generally that in the age that's regarded as the information age or digital age, where imparting ideas, giving information, hitherto had become while hitherto was localized, but now globalized, given the advance in science and technology and everything. I mean, if somebody is saying something, just as we say it now, we're having this meeting and discussion. Participation is global right now as we're talking. So it's an interesting time to live in. It's an important age. So in such an age, given all that we've witnessed in our country in recent time regarding the right to freedom of expression, or what is now generally regarded as the abuse of it, the dilemma that many have, including myself, is how fast we can hold to principles that protect the right to freedom of expression and the fulsome enjoyment of it. Because let's face it, there are moments when the right in popular assessment is so terribly abused that we wonder whether this right ought not to be further constrained. There are some moments. I've worked with the freedom of expression community in Nigeria, the media. At the time, we thought that we should present a bill before the National Assembly to decriminalize defamation. Yes, the case of Otonwako and the state was decided in Second Republic many years ago with the position of Olatawura JCA, and we cited that with approval many times in defense of the right to freedom of expression. Yes, the good work that was done by the committee, headed by no other person than the current DVC of University of Lagos, which led to the reform of the criminal law of Lagos State in 2011 is there, which did a lot to remove sedition and criminal defamation, leaving only section 57 in the criminal law of Lagos State, which is a section that deals with publication still of things that may cause public disorder and things like that. Those references are there. But the National Assembly, regarding the criminal code, has not formally amended out of the criminal code those sections. So those sections are still there. The section of sedition is there. The section on criminal defamation is there. And then the section on section 59 is also there. That has been a challenge, even after the FOI came into existence in 2011, so that when the Cyber Crimes Prohibition Act then came, people looked at that, and since that time have been using that. And in recent times, many people have been using that to deal with interpersonal issues, seeking assistance of the police to prosecute in respect of what is a crime under the Cyber Crimes Prohibition Act, Section 24, specifically because of the new amendment. So it is like, if I were to use an analogy, something that is akin to the movement for the abolition of capital crimes or abolition specifically of the death penalty, capital crime punishment, which has been a subject for years in Nigeria even. But just as that call remains extant, we've had in recent times promulgation of new laws, particularly since the spate of kidnapping, murderous kidnapping, became a major threat to life in Nigeria. Laws enhancing punishment up to capital punishment for kidnapping, particularly when weapons are used, even if death didn't result, death penalty is now being prescribed in those offenses, for those offenses. So it's a dilemma. But what I think is important is that in spite of those pressures, as it is said, you can be under pressure and you may want to say, no, this is not what we need to do. Principles are more enduring. And although one is not expected to be dogmatic, because we live in society and law evolves just as society evolves, one is expected still, in spite of things that occur, to deal with principles and hold fast to principles and say, regardless of what is trending and what is now going on, the rate of abuse of these rights as perceived by many, we still stick to the principle that it's better that these rights are enjoyed in our society because the existence of a democratic society largely depends on the extent to which the right to freedom of expression is enjoyed. Yes, the characteristic of a democratic society are well known. Yes, free press, rule of law, independent judiciary, periodic democratic elections, change of government, all these things are there. But I want to say, for the purpose of this conversation this evening, that at the very foundation is the right to freedom of expression. Even if you are talking about periodic election, is the expression of your democratic will, the expression of what your preference is. So the right to freedom of expression is very important. Now, the question you raised are important. What are these sections? Section 59, Section 204 of the Criminal Code, and Section 34 of the Cyber Crimes Act. My view is that as the law stands, these provisions are within the permissible limits of derogation from the right to freedom of expression. And I will give reasons for that. When Prof was giving his opening remark in the first segment of this discussion, and I was making the point about the need to ensure that the state does not take over. I hope I got the point right. Private injury regarding the issue of an alleged abuse of right to freedom of expression regarding defamation and making it a crime, given the jurisprudence of it, the historical background, particularly sedition, and all, which I agree with completely. Prof made an example that, well, if somebody were to say that she is not competent, she's not qualified, a professor and all that does not represent the truth, and so she may not bother about it. And if she bothers about it, certainly that shouldn't be what the state should be, lashing on to then say that a crime has been committed. I agree. However, given what Section 59 and even criminal defamation, likely as defined by the criminal code, is saying, I note that it's been expunged from the 2011 law of Lagos, is that if in defaming a person, you then extend that defamation beyond that person to implicate a public authority or a community, it indeed, in my estimation and opinion, it is justifiable to regard that as a crime, particularly when a criminal law has made it a crime. And I will not refer to this, just an hypothetical thing I want to say. If somebody calls me or label me or wrote about me or published a book about me and allege that I'm corrupt, I'm not an incompetent lawyer, and it stops at that, it's fair to say that that's my own personal worry. I could sue him. But if the person then says that I'm so corrupt that I'm the one that is giving money to judges all over Lagos State, and then corrupting the judiciary, that's implicated the judiciary. So it is not only my own person alone now that is allegedly defamed in that example, that has implicated. And so from a public law perspective, from a criminal law perspective, as the law stands, making that an offense will be justifiable. So it's no longer a matter between two persons that are, one defaming one and then the other saying that is been defamed. No. So Section 24, starting from that of the Cyber Crimes Act, as you 15, in that provision was more extensive and expansive. But now it's been, restricted. And as it is couched currently, my view is that it is justifiable. We will note, which is very instructive, and here I'm also not passing any judgment over the current goings on in the country. That section has not in any portion used the word defamation, if I'm correct. It's not used the word defamation. Rather, if you look at subsection 2C, it talks about threats. And if I may read, it says, contain any threat to harm the property or reputation of the addressee or of another, or the reputation of a deceased person, or any threat to accuse the addressee or any other person of a crime to extort from any person, firm, association, or corporation. Now, threats, extortion are all used. So, yes, reputation is mentioned, but it must go with threat. If you threaten somebody that, yes, I have something on you, so if you don't pay this money to me, I will release it to the public, and use any computer networks to do that, that will qualify for a cyber crime. So the way the law is couched currently, I would say that it's justifiable. And so in debating the continued or justification for the continued existence of this provision, we will have to balance. Prof, in our contribution, also talked about balance, and that yes, the reason for this right, for the existence of this right, we must always have recourse to that. Why do we need to have these rights? Why do we need to have this right protected? Because indeed, if that balance is not there, there could also be catastrophic consequences, as so that even for regular journalists, for example, it is true that the Cyber Crimes Act now is being used against individuals, who have used the social media against quote unquote celebrities, a church leader in the South who ensured that one lady who called herself a journalist was, or who is a journalist, not who called herself a journalist, was taken from another part of the country and into jurisdiction of that country, of River State, and successfully jailed there. Yes, the fear is that this could be used for regular journalists, and this may now become commonplace every time, because as we now know, the traditional print media has now gone digital. They are now online. So if their news item appears online and somebody alleges that it's been defamed, insofar as that will be used by a network or a broadcast or whatever, it will qualify as a cybercrime. That's our worry. And therefore, we will need to continue to engage this reality and then balance. But in my view, as the law currently stands, is the provisions that we have left are within the permissible limits. And that's to say, ending this intervention, that there may be instances in which persons who could otherwise conveniently seek civil remedies to allege defamation or civil libel now want to push their matter.
Mr. GT,
yes,
I was going to ask a follow-up question to that. So I think you can just hold on for a moment.
Okay.
Because in the third round, I have a question along that line. So quickly,
okay.
Turning to Mr. Timothy Ayoride, very briefly, as a young educated Nigerian, what advice will you give young Nigerians like yourself on how to behave responsibly when communicating on social media? Briefly.
Good afternoon once again. Yes, on the question on the advice to give young Nigerians on how to behave on the internet. So yes, we now have a new generation of people who feel they have to be heard and they must communicate. And if you look at the way the freedom of expression is structured, it is structured in such a way that it promotes people hearing their view. And like I said in the first round, the internet has provided a good and robust platform for youth to now hear their view. However, there are challenges on how to behave on the internet. My advice would be that first, be mindful of the content you share on the internet. There is a need, you have a responsibility to verify the authenticity of information you share before posting them, especially when it has to do with sensitive information, content that you know that may be harmful or that may incite hatred against a particular group or situations where it will cause harm to the reputation of another person. It is important that we act responsibly to verify the information before sharing. That's on the first one. On the second advice, it would be to exercise accountability. We should know that freedom of expression is not absolute. There is consequence for damaging people's reputation. So for every tweet, for every comment, for every post, we have to ensure that they align with not just the ethical standard, but they also meet the legal standard in such a way that we do not do things that consciously or subconsciously damage people's reputation or cause hatred towards a particular group of people. And the last one is that we must always show respect in our engagement. What we have currently now is a situation where everyone wants to bully another. We have the rich bullying the poor, we have the poor exercising the internet to also bully the rich or the famous in the society. So my advice would be that we should show some respect in engagement, avoid hate speech, cyberbullying, all forms of cyberbullying, and discriminatory language when communicating on the internet. It is better and desirable to foster constructive conversations on the internet that would, of course, promote understanding and inclusivity. So all in all, we must exercise accountability. We must be mindful of the content we share on the internet. We should not just cultivate the habit of just forwarding currently. Today, just a couple of minutes ago, we have on our class GC and all over the University of Lagos that just a screenshot that, oh, university is resuming this time around, and everyone is just forwarding to various group chats without verifying the veracity or the authenticity of the information. It doesn't speak well of us. We must at all times exercise accountability and be mindful of the content we share on the internet. Thank you.
Yeah, thank you. Thank you very much, Mr. Yorinde. Now we are gradually winding down so that we will give opportunities to participate online to ask questions. So, Professor Chenua, very, very briefly now, in the light of the impact of social media, do we need to re-evaluate the decriminalization of defamation? In the light of the fact that, more than ever before, you post something online and in the next minute, the thing is all over the world. Is there any need to reevaluate the decriminalization of defamation? Very briefly.
Thank you very much. From a pragmatic angle, I will say no. Because the bottom line is that criminalization of any conduct on its own does not necessarily change behavior. And if there's anything to learn, I remember when Mr. G.T. Ogunye referred to people who have advocated for death penalty for kidnapping. What we find is exactly what happened when death penalty was introduced for armed robbery. It didn't necessarily decline because sometimes the causative factors have not been addressed. We're just going down the spectrum and trying to deal with it at the end of the line. And secondly, the issue is, will we be able to police? No, we're not dealing with the we're not talking of prevention. We're assuming that just the threat of punishment. Do we actually have the capacity to make good the threat of punishment? If we really think punishment is as effective, which will be what we hope to achieve by criminalizing. I did say earlier on, when you talk about defamation, it's state resources that will be used for the investigation. It's state resources that will be used for the investigation. And the question is, what level of, really is in this 20, that's why I keep talking about the shifting mores and tolerance and everything. Will we really have breakdown of law and order simply because some things are said? The bottom line is that the criminal law is not the only way to regulate behavior. If you go to civil action, you also have sanctions. And so it is, number one, we will weigh down the police, because I tell you, it should not only be the elite who have reputation, everybody has reputation. So everybody will be able to use this law. Mr. G.T. Ogunye made reference to, maybe something capable of bringing the whole institution into disrepute. Well, maybe the whole institution has to work harder so that it is not in disrepute. And at the first suggestion, there are people who can defend it. I would just want to use this example. It was very profound for me. There was a time that a faculty member in University of Lagos was alleged to have committed rape. My niece showed me some chats on the WhatsApp, and I particularly saw one which said, if it was Dr. So and so, all of us will stand up in defense. And I thought, oh my God. The students who had chatted about all the other whatever, but they said, if it was Dr. So and so, now that they said, all of us will fight them hands down, because that cannot be. Then that institution needs to work hard to reduce, the believability of claims against it, the defamatory claims against it, the grounds that create. And that is why I say the problem is not going to be resolved by criminalization. It's going to be resolved by dealing with the things that actually lend to, people using the platform of the social media. And if I can just say, I will say suggestion to Law Society, Law Student Society. There is a professor in media, in mass communication, whose area, and he's a UNESCO expert, works with him, is social media use. We can go beyond just assuming that people will pick the information from somewhere, and we can structure systematic programs of education. We can structure all of those things. We can create the awareness, but we need to deal with the why people do it, which to a large extent is because, one, there is a basis. There's what's it called? I always call it trust deficit. There's massive trust deficit. And if the state doesn't deal with the massive trust deficit, all this whatever, and all of us will just continue to abuse in court, and then they will be swamped. Because if I now realize I can use the criminal law against my neighbor, I will use the criminal law against my neighbor for defamation. Everybody will begin to use it. So I will say, no, we do not need to introduce it through criminalization. Clearly, we need to review Section 24. And if we think that there are some interests that is compelling, then let's really define a new crime. But the truth of the matter is the risk of weaponization. And our reality in Nigeria is that we always weaponize. The police themselves weaponize criminal law. So if you expand the opportunities for weaponization, don't forget the man in Ogun State that was charged to court because he named his dog Buhari. I end on that note.
Thank you very much.
And it was the cyber crimes, they used the cyber crimes, that's Section 24.
Thank you very much, Rob. So that naturally flows into the question I want to ask Mr. G.T. Ogunye. Is the civil remedy option of an action in defamation an adequate remedy for any person aggrieved by any alleged defamatory publication? Hello, Mr. Will.
Yes, sorry. I was temporarily muted.
Okay.
Now, I said I will answer that question, but first, let me briefly provide an understanding of what a crime is within the boundary of our criminal legislation. A crime is simply what has been defined to be a crime. So, in dealing with the issue of criminal defamation, there must be a recognition that our criminal legislations still have criminal defamation as a crime, as an offense. And the fact that it was decriminalized in 2011 in Lagos and now in Edo State, and perhaps in the State, meant that at the time of decriminalizing it, it was a crime up to that point. Now, a crime, the criminal code categorizes crime: offenses against the body, offenses against human person, offenses against the state, offenses against public morality, and so on and so forth. But at the end of the day, the state is the one prosecuting the offense, save certain exceptions where private prosecutions are allowed. So the state is the complainant. The person against whom that offense has been committed is a nominal complainant. So if a person alleges that he's been defamed, at the end of the day, it's still the state that is prosecuting for criminal defamation. Now, civil remedy is very important, but it's also usually at a cost. The court may not look favorably to compensating the person who has been defamed and who has successfully proven that has been defamed in the recovery of damages, to pay the cost of the litigation. I'm not talking about the nominal cost that is awarded by the court, a 50,000, 250,000 cost follow event. No, I'm talking about the cost of hiring a lawyer. There is no authority that allows a court of law to, as the law currently stands, to make a party to a case bear the cost of hiring of lawyer of his adversary. So yes, civil remedy is there, but it may not be adequate. Particularly as I've explained, if the defamation goes beyond the person defamed. Otherwise, civil remedy is adequate in the circumstances, if you ask me, because it allows for damages to be given. It allows for the libelous publication to be withdrawn, for example, and so on and so forth. Now, in recent times, because we are lawyers to some online newspapers, in particular Premium Times, for example, in many of the cases that we've handled, we've seen increasingly claimants pressing for the deletion of the offensive publication. Unlike in the past, when in the print media, what are you going to delete? It's been printed and it's gone out. So you cannot get an order to go to various homes and places in Nigeria to withdraw an already published newspaper, for example, that allegedly contains a libelous material. But for an online newspaper, which publication is always live, it's possible to get a remedy, to have it totally obliterated. Yeah, it could still be somewhere, in the internet world or the internet environment, but that major offensive publication will have been deleted and all that. So this remedy is always there and is very effective, I must say.
Thank you very much, Mr. G.T. Oguye.
Yes.
Now we are in the session where we will allow questions first. If you have a question, you should raise up your hand, your digital hand, and then we'll enable you to unmute. You tell us your name, and please, let's obey the rules as we have set. We're not commenting on the recent events in the media. All we are looking at is interrogating the limits of the criminal law in regulating freedom of expression. So we want our questions to be limited to that. We're not sitting as a court over any current event. So if you have questions, you can indicate by raising your hand, and then we will allow you to ask your question. Okay, I cannot see any hands up. If you have comments, as well, you can indicate. All right. So if you don't, okay, I think I've seen a hand. Bang Longe. Yes, you can unmute. Please tell us your name and just go straight to your question, because we've spent over 1.5 hours already.
Okay. Thank you so much, sir. Prof. Can you hear me clearly?
Yes, we can hear you, Mr.
Okay. Thank you so much, sir. My name is Bankole Longe. I'm joining in from Canada. Thank you for this opportunity. I want to appreciate Professor Sonny and Professor Ashenua, and even Professor Akim Bello. You were all my lecturers back in Unilag. So I just wanted to is a comment to just say that it's important for us to, I mean, as a nation, perception is everything. So just like what Professor Ashenua said, we don't have paucity of laws. So the issue is not the laws and all. So is the perception of the enforcement of the laws, the perception on the part of the public. So, just like what Prof. Ashenua said, so there's a trust deficit, there's trust deficit on behalf of from the part of the public to the agencies and the institution of states, so there seems to be selective applications of the law, so even where and even about defamation, who determines what is defamatory? Who determines? So it's meant to be left to the court to determine, right? So, but in the process of enforcing my rights, if I feel that your freedom of expression has encroached on my rights, and it has defamed my reputation in the eyes of the public. So what procedure do I adopt to enforce my rights? So if once I use the instrumentality of the state to enforce my right, generally speaking, the public seems to have what is it now, like sympathy. Yes, there's sympathy for the underdog in every situation. So we need to encourage and put in place situations where the public will trust the institution of the states. So even when the agencies are doing their job, there's no misconception, there's no a prejudged opinion that there's bias there, that is because the person is wealthy. So that's just my contribution. And
thank you very much.
And just a quick one, sir. And and in looking at the limitations, the limitations of the right, even in Canada, there are exceptions. Here we have it as there must be where there's reasonable limits prescribed by law, as can be demonstrably justified in a free and democratic society. Look at the emphasis: free and democratic society, just as Professor Ashenua said. So it's important for us to to continue to enlighten ourselves, enlighten the public through different avenues, so that we all know what we are getting into. Thank you so much. Yeah.
Thank you very much, Mr. Bankole. Thank you. Mr. Oluwo Oladipupo. You can unmute.
Okay, sir. Good afternoon, sir. Good afternoon, sir. My name is Oluwo Oladipupo, a 400 level law student, and I would just like to ask a question, please. So my question revolves around the sphere of like online defamation, actually, because recently, like, there have been like cases where people publish things online and they thereafter go after the institute cases bordering on online defamation. So how does like criminal law want to like regulate that? Or are they already like, aside from the Cybercrime Act, like is there any other mechanism that can be used to like enforce that?
Okay, I guess either Professor Ashedwa or Mr. GT Ogunye can quickly respond to that. And I can see that the Dean also wants to ask a question or make a comment. So we'll get to the Dean shortly. So Professor Ashedwa or Mr. GT Ogunye.
Yeah. Thank you, sir.
Well, if I may attempt an answer.
Very briefly.
Yes, a cyber crime is a crime because the legislature has codified that conduct and has made it a crime in Nigeria. Otherwise, it won't be a crime. And being a crime, punishment has been prescribed for that crime, apart from the definition of the crime. And the worry that must have led to that law and that offense being made an offense is the general belief that the social media is being misused and indeed can be used to cause a lot of harm to society and the public. In many of the cases that I've seen, and we are all living witnesses to this, the people who make very wild or substantiated and outrageous claims in the social media, and they have a lot of following, in our society. They have the right to be followed, and people who are following them have the right to follow them. But in making these claims, they then insist, if you believe that you have been defamed, go and sue me to court. So they think it's a circus, and the society, can really take that to be very offensive. And then, that society can criminalize that kind of conduct and then say, no, this is not, particularly when potentially or in reality, it can harm not just one person, but people in the community. I mean, they are, and we can debate whether this is really harmful. There are, in recent times, there is, we know this now, and this is my personal view, but we know this. The veteran actor, Olu Jacob, has perpetually been dying in the hands of those who use the social media. So much so that the mainstream media will now have to be reacting to it. And in a way, thereby counterfeiting the content of even the mainstream media. When a television house, for example, says what's trending and picks all sorts of things from the social media because they are trending, wittingly or unwittingly, that thing that is trending is being mainstreamed in the media. And that can cause a lot of problems. We've seen that happen in one of the television networks in recent time, just because of what is trending, being reflected or being monitored and then being debated in the mainstream media. And so because it's defined as a crime and punishment has been prescribed for it, it has to be punished according to law. That's, in truth, another definition of the rule of law. The law has prohibited it. It's an offense. And so if that offense is committed, then the law has to take its course, as it is said.
Okay, thank you, sir. So let me allow the Dean.
Can I just make a quick comment on that?
Yes, Prof.
Thank you very much. Yes, thank you very much. I think there's a very important comment to make, and we mustn't lose sight of it when we talk about criminalizing all this conduct. It's that once it's a crime, the burden is on the prosecution to prove for those elements of and the question will be, how do you measure? If you say that somebody was defamed because something was online, how do you measure? And that's why I think someone had said earlier on that it is quite subjective. Are you going to carry out a survey you know, to find out how many people really believed and all of those things. So it's going to go back to perception, that the perception that the person has been defamed. And I think it's also when you say online defamation, yes, the fact is that for as long as it's in the statute books, it is a crime, and it will have to be addressed, you know, following the normal criminal process, requiring the prosecution to gather the evidence and be able to present it before the court and satisfy the courts, you know, beyond reasonable doubt that this person did this. And, you know, all those subsidiary things as with intent to do this and do that will all become relevant. But I think it's very important, you know, that first statement I made about how would you know? So there was this, in recent past, we've had this case of Erisco tomato paste. And the question is, so if I go online and I say, I don't know this thing about this tomato paste that I bought, it's just too red. I'm not sure that, are you sure it's not chemicals? And the next thing is that's online defamation. And that was what happened in that case. And there was a lot of hounding. And though, again, it's about, I will just always caution, you know, about the risk of weaponization. But of course, for as long as it's in the statute books, it is the law and it will follow the normal process. And that's why the issue of decriminalization continues to be a constant conversation.
Thank you. So, Dean, Professor Bella Sonia said.
Yeah, thank you very much. Imagine if you know this conversation and our people are involved in the reform of Lagos State criminal justice system, and then the law remained the way they had been even since pre-colonial days. You can see how excited I am that, you see, as far as intervention in our faculty is concerned, we are progressive-minded, and then we should be able to support state and institutions to look at their laws and get them up so that they can be fit for modern society. I like the balance in terms of sustainability and efficiency. And I recall my experience as a youth corper in Benue State, where I started my practice. I can say I cut my teeth in litigation at that time. There used to be criminal summons. Criminal summons allows a litigant to pursue criminal action at his own cost, even on issues of trespass. So I will want experts' view on this, because it will appear as if that, to some extent, kind of address the issue of using state fund to fight private interest. And I like GT's angle on the downside of criminal options, because if you look at Smith and Selwyn, you can pursue either of the options or even both concurrently. But a situation where civil options are fraught with impossibilities. I mean, I win, the other party can appeal, then it goes through what you call a cycle. So I want to, it doesn't appear to me that what we have in the North, even in terms of criminal, civil criminal summons is an option, but it exists. So the challenge is for states to look at the state of their law and actually get them up. But I would like to have your comments on it anyway.
So Professor Ashenua, I'm sure you would like to comment about that.
Yes. Yes, of course, there have always been crimes that you can privately prosecute, and we know the circumstances in which that power was again taken away in Lagos State, for example, a couple of years ago. I think the same danger that Professor Sonny, the dean, sees with the civil justice system. It's the same danger. The problem is that our justice system needs, you know, it's not, it's part of the deficit. The criminal justice system does not work better. What happens is that half of the cases will not even get prosecuted. The people will just be punished by being held in custody pre-trial. Or even when they're prosecuted, the quality of evidence will be so poor that the cases will be lost. So at the end of the day, it's like, just first of all, hold them, just show them, just let them go and whatever. Because we have a problem with the justice system, starting from criminal investigation. So the mere fact that you have a problem with the civil justice system cannot be sufficient justification for then saying use criminal justice system. That is why understanding the philosophy, the rationale, everything about criminalization is something that we must be consistent with. And once we know why it is we want to criminalize conduct, we use that yardstick to deter, not just because, oh, you won't get justice this way, so let's criminalize. You won't even get justice through the criminal justice system, like I've said, because it is unlikely you will get a conviction. You will just hold the person. Even if the evidence is there, we know that the quality of prosecution might be so poor. We know all the things, the delay. We talk about appeal, appeal, appeal. The criminal trial itself won't end. So I don't think that that is sufficient reason to allow for private prosecution of a crime in this particular case.
Thank you very much, ma'am. And as a moderator, if I'm allowed to canvass my own view, I think I wholly support the view just expressed by Professor Ayodele Ashenua. There is a hand that has been up since, and I think will allow him, and then probably, you know, gradually wind up after that. Anyolaja, Adam, you can.
Are you disregarding your dean's request? I'm sure there will be a few people who still need clarity on some of these issues.
Well, we have not seen. Applying presumption of regularity to him. We have not seen their hands.
Good afternoon,
so,
sir. Sir, good afternoon. Sir.
Yeah, good afternoon.
Yes, sir. This is Mayala Jadam Oriola, undergraduate level student of the University of Lagos Faculty of Law. So the Professor Asenwa, Our Excellency, ma, said.
Excellency? No excellency here. Go on.
But it's not defamatory.
I'm very sorry. We have, Madam said, the police weaponize criminal law. So is there anything we can do to make sure the police, or to stop the police from weaponizing the criminal law? Because it is what they really make use of. And yes, we stand a very big chance to hinder them from weaponizing that criminal law. So how do you think we go about it, ma?
Okay, I'm glad you said that you're in year 1. I'm hoping that by the time you get into my class in year 3, and by the time you get done in year 5, you will be committed enough to be somebody who uses everything, whether it is their skills as a practitioner from the bar, or it is their skills as a lawmaker, or it is their skills as a private citizen, howsoever, to work for the improvement of the justice system. The answer to that question is not straightforward. It's not one. So it's not something I can say, oh, this is the answer, because it's multi-pronged, different causative factors. But one that we have just talked about also is, you know, the fact that the way the system rolls, maybe sometimes because of weak capacity, sometimes because of corruption, sometimes because of a wrong perception. You know, there used to be a joke that I heard that during the colonial times, when the native police will say something like, Oni Bombe. I say, what is the word of Oni Bombe? Amu ninja muni wonito Oni Bombe. Arrest me, let's get the case done and done with, not the fact that you use, your perception of the criminal law is now I got you. You don't, nothing you can do. No, the prosecutor is not a persecutor, and the criminal law is about doing justice. It is not just about apprehension of the individuals who have committed a crime and just using the whole weight of the system, to lock them down at that point. But I'm hoping that we can have other engagements, and in particular, as we get into class, to take some of our other topics, we will also have the opportunity to engage with students. I hope that helps to answer the question at the student level. Thank you very much.
Thank you very much, Prof. So I think we are gradually winding down. So I would allow the members of the panel to give their parting shot, your final words, not more than 2 minutes, your parting shot. Starting with, okay, let's start from the other way now. Mr. Timothy Ayorinde, your parting shot. You have to unmute.
Hi, everyone, once again. Good afternoon. Yes, on a final note, I would urge everyone, particularly the younger generation, to always be conscious of things being disseminated on the internet. The internet can be used as a good medium to articulate our thoughts, to express our voice, and of course, to contribute to meaningful discussions in the society. However, we must also take note of accountability on our own part. It is our responsibility to always show accountability, to go beyond the surface, to seek the veracity of the information being disseminated, as well as also be mindful of spreading hate speech. Cyberbullying is not advisable, it is wrong, and if you engage in such, you may be criminally penalized. So yes, on the final note, we have to be conscious of things being pushed on the internet. We have to be our brother's keeper. Thank you very much.
Thank you, Mr. Ayorinde. Mr. GT Oguye, your parting words.
Yes.
In not more than 2 minutes, sir.
Yes, thanks for inviting me again. I'm really grateful for this opportunity. Now, criminal law and its enforcement has its many challenges. And even when criminal laws are being enforced, the philosophy behind the provisions will continue to agitate our minds. However, in superintending society or governing society, there are laws that have to be strictly enforced, even when we recognize that rights of private citizens are also very important. In any case, the ultimate benefit of any law in any society is to ensure that society is orderly, society is peaceful, rights of individuals are enjoyed by those individuals, and they are not recklessly, trampled upon either by state machinery or by private citizens themselves. And I think that these issues will continue to be debated as our society evolves. Before now, we weren't talking about cyber crimes. Now we have these cyber crimes all over the place because the society has deemed it to be a crime. I also believe, therefore, that looking at the issue of defamation, whether there's justification for a continuing existence in our statute book, or whether they will be decriminalized, is an issue that will continue to occupy our time. And I think that the more we focus on this and discuss this matter in enlightening fora like this, and not so enlightening fora like this, we'll be able to make headway and come out with a situation in which our society is better run and better governed under the law, so that justice will be for each and all.
Thank you very much, Mr. Jitioguye. Professor Ayodele Ashenua, your parting words, ma'am.
Thank you very much. I think I want to endorse the last statement, which is simply let the conversations continue. This is about defamation today. It can be about another thing tomorrow. The bottom line is that law will always have to balance interests, at any point in time. And so but what is important, the criminologist will say, is that we should not have moral panics, because when something happens and then we panic around it, we then coalesce, it's like in those days of witchcraft and everything. So we must be careful not to fall afresh into the cesspool of moral panics that makes us, redefine boundaries and close and things like that. I believe that we should strain more at strengthening institutions and our systems. We should strain more at strengthening institutions and our systems, rather than continue in this persistent belief that once you criminalize, you have solved the problem, or once you increase the penalty, you have solved the problem. I thank you very much. My only pain is I don't see that this seminar has been recorded. Has it been recorded? Will we have it? Oh, it's been recorded, so that...
And it's also on the faculty YouTube channel.
Okay.
It's live on YouTube, yeah.
Thank you very much, so that we can get the feedback and the conversation can transcend the number of people who are attending here. Thank you very much.
Thank you very much, ma'am. So I would like to invite my colleague, Dr. Folashade Adebite, who is a member of the Faculty Round Table and Seminars Committee, to do the vote of thanks.
Okay, it has been thank you very much, Professor Bello. It has been a very wonderful and worthwhile and very engaging discussion throughout. And let me start my appreciation. I think I'll start from the rear. Permit me to start from the rear. I'll start from our participants, online participants. It has been a wonderful attendance. I think there was a time we were up to 60. I want to appreciate you for finding time to come around to engage in this discussion. Thank you for your time. Thank you for giving us, spending your data, so to speak, in attending the discussion. And like Professor Ashenua said, we hope that this discussion will continue so that we can jointly make our society a better place and probably strengthen our institutions so that we can get better results from things and not just act on the spur or the emotions of the moment. So let me go back and start with, I'll call out my employer for the purpose of this discussion, Professor Ayodele Ashenua. She's the DVC, so I will call her my employer. Thank you so much, Ma. She's been a wonderful mentor. She's somebody that we admire and we've learned from. Thank you for finding time out of your very busy schedule to come and give you insight into this discussion and to share part of your knowledge. Going again, I'll appreciate Mr. G.T. Oguye. Thank you so much. It's been a very, very enriching discussion and perspective from your part. Thank you for coming around. Thank you for sharing your thoughts. Thank you for sharing your knowledge as well. I'll go straight next to Mr. Timothy Ayorinde. Permit me to say that the Bible says that out of siblings and babes, he has ordained perfect praise. He has actually made very, very worthwhile contribution, or albeit he's a law student, but we can see the caliber of people we are producing in our faculty of law. Very intelligent, very brilliant, very brave, and very articulate. He's our LSS leader. I call him Mr. Presido. Thank you very much. And you've given us your perspective, even from your age group. And I believe what you've said today, you're speaking directly to your generation, and I think they will pick you and they will believe in you and believe you for what you have said, because it's coming from somebody representing their age group. Let me appreciate the moderator, who is my chair in our committee, Professor Akim Bello. Thank you for your commitment. Thank you for leading us. Thank you for always encouraging us. And you're a very good cheerleader, I must say. And finally, I want to thank the ballet, the Olori Ebi of the Faculty of Law, the big masquerade, our dean, the incomparable Faculty of Law, Professor Abiola Sonny. Thank you so much. Thank you for SAN. Professor Abiola Sonny, Senior Advocate of Nigeria. I want to say a big thank you. Thank you for the vision, because it's your vision that brought about the resuscitation of the Roundtable and Seminar Committee. Thank you for your vision. Thank you for nudging us on. Thank you for, I remember the last time I was in your office, you were like, Shade, what is happening to the Roundtable Committee? I'm going to score you. I'm going to score you. Thank you for pushing and pushing. Thank you for your leadership. We appreciate you. And generally, overall, let me say we thank God. It's not unusual in Nigeria to have a break in network and things like that, because that was my apprehension and agitation when I was speaking with Professor Bello this morning, that we need to get a lot of networks around so that if one should fail, peradventure, if the moderator's network fails and it goes off, somebody can pick it up and talk. And we're just putting our heads together to see how we can just make it very smooth and effortless. And I want to thank God because He actually allowed us to have a very smooth discussion. I'm not taking it for granted personally. Having 2 hours of uninterrupted data network failure, I think it has to be God. So we thank God. Finally, we hope to call our participants again, because this is just the start. It's a tip of the iceberg. We're going to be calling you often and often to come around so that we can have vibrant and engaging discussion. And we hope that you'll always come around. So thank you, Mr. Moderator.
Thank you. I think the dean wants to say something, because I saw his hand.
No, not at all.
Oh,
if
okay.
I say anything now, it will be an anticlimax.
Oh, okay.
You guys have done well.
Okay, so we thank everybody.
On a lighter note, you almost think that GT is an akokite. He spoke like an akokite. But I can see that the 2 of you went to the same school.
We went to Unimed.
So,
yeah.
Okay.
Thank you so much.
Bye-bye, everybody.
Thank you.
Okay, then, bye. Thank you very much.
Bye.
Bye.
Bye. Bye.
Thank you. Bye.